So good morning, everyone, and welcome back to our weekly webinar series. Today is our 90th episode, and over to Anil sir to take this deliberation forward.
Thank you, Ankit. So, welcome to this 90th episode of AAA Weekly Webinar Series. 90 episodes without any gap every Saturday. Earlier it used to be Sunday, but then it shifted to Saturday. 90 episodes without any gap, and we are very soon we are going to complete 100 episodes, and then we will celebrate also. The subject today that we have taken up is a 7 judges judgment of Honorable Supreme Court. That is in the case of an arbitration judgment, and the title of that judgment is this Bhaskar Raju and Brothers versus Dharma Ratnakra Rai Bahadur Arcot Naran Swami Madulyar Chetram and other charities. We are not going into what was the dispute, what was the facts of the case. We are only trying to deliberate today on what exact law has been set by the 7 judge bench of Honorable Supreme Court. This can also be called as constitutional bench, rather a larger constitutional bench, because the constitution bench should have at least 5 judges. So in this case, it was 7 judges, because in this case, probably the review petition was dismissed on the grounds of merit as well as on delay. And then it was basically a curative petition, which was filed by Bhaskar Raju and Brothers, and which was held. And this was the judgment. And the judgment was again dated, it was dated, I believe, 13th of December 2023. And the 7 judges in this case was Dr. Justice G.Y. Chandrachud, the Chief Justice of India, Mr. Justice Sanjay Krishan Kaul, Mr. Justice Bhushan Ramakrishna Gawai, Mr. Justice Surya Kant, Mr. Justice J.B. Pardiwala, Mr. Justice Manoj Mishra, and Mr. Justice Sanjeev Khanna. Now, why we are discussing, primarily our subject is insolvency and our subject is SURFACE. But this particular 7 judges bench, in fact, is very, very important to understand the overall importance of a document, whether the stamp duty is paid on the document or not. So each and every agreement, each document is governed by Indian Stamp Act. Now that Indian Stamp Act, there are varied judgment. And in fact, in case we see the various, the background of this judgment, is the background of this judgment is that there are various judgments which has given some kind of varied opinion. In fact, I have also called 2 advocates who have experience of arbitration, Stamp Act, and also they work with us on insolvency cases. Ankit, can you see whether they have joined? Amar Vivek has joined, and one practicing advocate is Advocate Amar Vivek. He also practices arbitration, and then he is actually more involved with us as an independent lawyer on insolvency and also on SURFACE. Welcome to this 90th episode, Advocate Amar Vivek.
Hello, sir.
We were
Good
also
morning.
expecting Advocate.
Thank you so much, sir.
Good morning, Amar. So, Amar, I am just giving the preamble of this judgment, and there will be some questions that I would be asking you, and those questions would be really, really relevant for our audience. Those questions will be kind of generalized question, which is for also for the understanding. See, Amar, also try to see in case you can get some concentration. In
Yes,
various
sir.
cases, even in insolvency
Yes.
law, the
Yes.
documents have been rejected by NCLT because of the inadmissibility, as the stamp duty has not been paid on those agreements. This will have impact. This judgment will have impact on those kind of cases also, where the petitioner is trying to submit a document or respondent is trying to submit a document, and the document is otherwise both the parties agree that yes, this document was executed, but someone will object that this document is not properly stamped, so this is not admissible in the court, and that also in NCLT court. So NCLT is also taking cognizance of inadmissible documents because of under stamped or non-stamping. That
Of
also I
course,
will.
this judgment is going to have a lot of impact on NCLT apprehending those documents which were not properly stamped, because the law has been settled that stamping is a defect which can be cured.
Yes. So this is a 7-judge bench of Honorable Supreme Court which has given a wonderful judgment. And I was only trying to say, Amar, there is a background to this. In fact, in 2017 judgment, in the case of SMST Estate Private Limited versus Chandmari Tea Company Private Limited, the 2-bench judge of Honorable Supreme Court held that an arbitration agreement in an unstamped contract could not be acted upon. In another judgment in 2019, 2-bench judges of Honorable Supreme Court in the case of Garware Wall Ropes Limited versus Coastal Marine Construction and Engineering Limited, they also relied upon SMST Estate, which I just said, a 2017 judgment, to hold that an arbitration agreement in an unstamped commercial contract would not exist as a matter of law and could not be acted upon until the underlying contract was duly stamped. Now, there are two things now. In this particular judgment, the Honorable Supreme Court is also talking about the separability of the two contracts or two clauses. One is the underlying commercial contract, and the second is the arbitration agreement. In this particular, in case there is a possibility that the underlying commercial contract is duly stamped and is valid and is admissible as a document. However, the arbitration agreement is not properly stamped. That also is something that I will ask Advocate Amar Vivek. Then later on in 2020, a 3-judge bench of Honorable Supreme Court in the case of Vidya Drolia and others versus Durga Trading Corporation. In fact, they cited this Garware wall rope also with the, but then they were in this particular case, it was held that an arbitration agreement exists only when it is valid and legal. That was something which was held in this case. However, in 2021, another judgment that was from 3-judge bench of Honorable Supreme Court, that was NN Global Mercantile Private Limited versus Indo Unique Flames Limited. In that case, in fact, the government in fact held in little detail that the arbitration agreement being separate and distinct from the underlying commercial contract would not be rendered invalid, unenforceable, or non-existent. The court held that the non-payment of stamp duty would not invalidate even the underlying contract because it is curable defect. So in the process, the court adopted a view at variance with SMST Estate versus Chandmari Tea Company Private Limited and Garware Wall Rope. So some variation, but the same 2 judgments were adopted, and the variation was the understamping is a curable defect. Then in this case, the Constitution bench, in fact, in the case of NN Global Mercantile Private Limited versus Indo-Unique Flame Limited, that was in 2023 by majority of 3-2, held that NN Global does not represent the correct position of law. So then, therefore, in this particular judgment, a review petition was filed and which was delayed. However, since this Honorable Supreme Court has seen that varied opinions are coming, first from 2-judge bench, then from 3, then from Constitution, and then in this particular case, or rather it's another case, Bhaskar Raju and brothers, the Supreme Court decided to take up this issue as a curative petition. And the issue before the Honorable Supreme Court in this case was whether arbitration agreements that are understamped or inadequately stamped would be non-existent, unenforceable, or invalid if the underlying contract was not stamped. So in this case, underlying contract was also not stamped, and therefore the arbitration agreement that are unstamped or inadequately stamped would be non-existent, unenforceable, or not. So this is the basic question in this matter. So therefore, we actually would not like to go into the detail. And it was also somehow in this judgment, it was held that the court must determine whether a document is sufficiently stamped, even if such an objection has not been raised. So in this judgment, even the courts have been given this primary duty to determine whether the document is sufficiently stamped, even if such an objection has not been raised. So in this particular judgment, it is very clear that the ambit of the court's duty extends to not just inquiring whether any objection is raised about the sufficiency of document, but also satisfying itself that such documents are properly stamped. However, this will no doubt take more time to settle the dispute between the parties, although the courts are definitely said to be taking up this duty. So let us see actually what finally actually has been held in this case, in this particular judgment. The court has actually finally held a few doctrines which are very, very important. So we would first see into those held part of this judgment, and then I would say I will ask some questions from Advocate Amar Vivek. Now, the conclusion in this judgment is agreements that are not stamped or are inadequately stamped are inadmissible in evidence under Section 35 of the Stamp Act. Such agreements are not rendered void or void ab initio or unenforceable. Then the court continues to say non-stamping or inadequate stamping is a curable defect. Then the Honorable Supreme Court is saying an objection as to stamping does not fall for determination under Sections 8 or 11 of the Arbitration Act. The concerned court must examine whether the arbitration agreement prima facie exists or not. The court says any objections in relation to the stamping of the agreement fall within the ambit of the arbitral tribunal. So the arbitral tribunal is also kind of having the jurisdiction to decide the objections relating to the stamping of the agreement. Even then the court further says that the decision in the case titled as NN Global Mercantile Private Limited versus Indo-Unique Flames Limited, where the apex court held that an arbitration agreement being separate and distinct from the underlying commercial contract would not be rendered invalid, unenforceable, or non-existent, overruled. It will be is overruled. Now, see, like when I see the basic impact of this judgment, the basic judgment is like I need to understand what is the difference between an inadmissible document or a void document only with regard to stamp duty payment. So can I seek your mind, Advocate Amar Vivek, the difference between
Yes,
an
sir.
inadmissible document or a void document, only considering the stamp duty part of it?
Sir,
Yes.
the two difference that one can identify between these two concepts, inadmissible and void. So, inadmissible documents are the one which the court cannot rely on for the purposes of taking it as an evidence in during adjudication. However, an agreement which is void cannot be relied in entirety by either by the parties themselves to claim any right out of it. So only for the purposes of adjudication, a document can be held to be inadmissible, but the rights can still subsist in those inadmissible agreement, matlab inadmissible documents. But in case of void documents, there are no rights which can be conferred by way of such void agreement. So technically, the basic difference is that rights may exist in case of inadmissible documents, but the court cannot adjudicate it or cannot consider it while adjudicating. On the other hand, in case of documents which are void, they cannot be even relied for taking any reference of any rights that can emanate from those such documents or such contracts. Lokesh sir is also here. Lokesh sir, would you like to add something up in
So
this?
I will introduce Lokesh Malik, Advocate Lokesh Malik. He's also having experience in arbitration cases and also work with us in many cases on insolvency and bankruptcy law. So welcome to Advocate Lokesh Malik in our 90th episode of AAA Weekly Webinar Series. Lokesh, can I ask you a question on this?
Thank you so much, sir. Sir, as Amar correctly pointed out, that inadmissibility particularly does not deal with the enforceability and being void of an agreement is clearly speaking of its enforceability of court of law. So the basic difference which Amar pointed out is very correctly, and I would also go for it here.
So we have a question from Mr. Lalit Maheshwari. He's asking that an unstamped document, a plain paper document, can it be cured by paying required stamp duty?
Very
I think
important question.
Anil sir will come to this because we have had a lot of discussion on this during in some of our cases in NCLT. So yes, it can be cured, and I think sir is going to deal with it, and then we'll have a proper discussion on this. And Supreme Court has also dealt with it in a manner saying that you have to understand that the Stamps Act is an act of 1899, that is during the colonial time, and that act was enacted only for the purposes of generating revenue. The underlying object of the act is to generate revenue, nothing else. So it will not
Absolutely. Yes.
render
No,
any right
Amar is actually right. Yes.
nullity.
Please go ahead. Please go ahead. Please go ahead. Sorry.
Exactly. So I think we'll have a proper discussion on that. But to answer this question, right as of now, a document defect can be cured by paying proper fees of proper revenue to the court, and court is only a, you can say, a guardian to ensure that you have properly paid revenue to the government. Nothing else court can do so far as the validity of the agreement is concerned, and that can be cured. And it is a concept which is called and which is very popular in corporate law. Anil sir and Ankit sir, both of you are aware that in companies law what happens, that there are compoundable offenses which can be compounded, for which you can pay the penalty and you can get out. So this also is a compoundable, I wouldn't say an offense, but compounding can be done, and the document can be relied subsequently by paying proper revenue to the government.
So one more question.
Yes, Samar. I think
Question
like
that comes to me from the NRRA perspective. We have been talking about how NRRA is not feasible because without stamping, the validity of the assignment deed will not be there. So going by this interpretation, can't today, is it possible for somebody to acquire NRRA assets by paying, maybe not the stamp duty on the gross value of those assets, and maybe cure the defect at a later stage in case he realizes more money out of the process?
Of course, sir. Usually, what happens that this is the you can say a modus operandi for a lot of people today. That's
Hmm.
people who know that the rights arising out of the contract will remain unchallenged by any person, and that there is not going to be there is not even an iota of doubt that there will be a dispute. So people usually don't pay stamp duty, and they simply continue without paying the stamp duty. Like Anil sir pointed out initially, what the court has said. The court has said that it is a defect which can be cured. It does not render the rights of parties a nullity. So, if a defect can be cured, the right will subsist for adjudication. The court will not consider that document, that contract only for adjudication, but otherwise it will be enforceable in terms of Indian Contract Act.
Very, very right. Very right. So, Ankit, is there any other question from audience?
There's a question from Mr. Deepak Garg. Mr. Deepak Garg is asking that since the judgment pertains to arbitration agreements only, whether this judgment is applicable on all other agreements also. So basically, I think he wants to understand if this interpretation with respect to curing the defect is applicable to other agreements also as per the judgment, or it is only pertaining to arbitration agreements.
No, in this particular judgment, what this Honorable Supreme Court has dealt with into two issues. One is the underlying commercial contract, and the second is the arbitration agreement, either within that particular or a separate agreement. So this judgment is basically pertaining to these two issues, like the separability of the underlying commercial contract and the agreement for arbitration. However, the basic concept which has been discussed in this judgment is the stamp duty. Section 35 of the stamp duty, if I'm not mistaken, Amar, which says that the court has a
Correct.
duty to
Correct, sir.
impound. Yeah, the court has a duty to impound any understamped or non-stamped document. The court will send that document to registrar of stamps, and the penalty as well as the stamp duty would be paid. Only then this particular document would become admissible as an evidence. However, in most of the cases, I have seen that the courts do start taking the cognizance about the underlying commercial contract, take some interim measures, and in the meantime, the courts are giving opportunity to the person who is submitting that document to get it cured. Is that correct? My understanding is correct, Lokesh? So this is what I
Very correct,
understand.
sir. Very correct.
Most of the courts are not saying that the underlying commercial contract is also void. So in this judgment, I would now read a couple of things which has been decided by this Honorable Supreme Court in this 7-judge judgment regarding the inadmissible and void. What is the difference in this particular judgment? Give me a minute. I will just see that relevant part and read few of the part which is held by the Honorable Supreme Court. Now, in this case, the court noted that when an instrument is inadmissible, then the court may or may not consider or rely upon it while adjudicating. However, a void instrument renders it unenforceable in a court of law. That is the basic difference between void and inadmissibility. Because in the first case, it is the court may, but in the second case, that particular instrument is unenforceable in the court of law. Then the court further says regarding this inadmissible inadmissibility or voidness. The admissibility of an instrument in evidence is distinct from its validity or enforceability in law. Section 2, subsection G of the Contract Act provides that an agreement not enforceable law is said to be void. Admissibility of a particular document or oral testimony, on the other hand, refers to whether or not it can be introduced as evidence or not. An agreement can be void without its nature as a void agreement, having an impact on whether it may be introduced in evidence. Similarly, an agreement can be valid but inadmissible in evidence. Section 35 of the stamp duty is unambiguous. It stipulates that no instrument chargeable with duty shall be admitted in evidence. And the term admitted in evidence refers to the admissibility of the instrument. Section 42, subsection 2 states that an instrument in respect of which stamp duty is paid, which is endorsed as such, will be admissible in evidence. The effect of not paying duty or paying an inadequate amount renders an instrument inadmissible and not void. This is the final held part of this judgment. Non-stamping or improper stamping does not result in an instrument becoming invalid. The Stamp Act does not render such an instrument void. The non-payment of stamp duty is accurately characterized as a curable defect. The Stamp Act itself provides for the manner in which the defect may be cured and sets out a detailed procedure for it. It bears mentioning that there is no procedure by which a void agreement can be cured. So very, very clear, a void agreement cannot be cured. However, an inadmissible agreement can be cured, and further it can be made as admissible document. Anything which Ankit or Amar or Lokesh can comment on this inadmissibility and the void agreements, because this subject we have to conclude, and then I will move to the other, which is something which is called the how the arbitration law is important in this country, and also we will see the judicial discipline. These two subjects these two subjects are also dealt with in this particular judgment. First of all, let us conclude inadmissibility or voidness.
Sir, on this point, only one thing I would like to add that and conclude with this, that like you have mentioned and what the court has said, that in case of document being inadmissible, the court may or may not. So there is a discretion given to the court to entertain it or not to entertain it for adjudication. But in case of documents which are void, the court shall not. So there is no scope for discretion left to the courts by the legislature. So that is the pivotal difference between an inadmissible and a void document. Now, sir, coming on to the second aspect, what I wanted to initially say, that we have to understand the underlying object for which the Stamps Act was enacted. Now, the Stamps Act was enacted in 1899. Today, it is the power which has been given to the government and which is exercised by way of Stamps Act is exercised by Ministry Department of Revenue. So today, sir, we can understand that the purpose of the act altogether is to generate revenue out of the instruments which are being executed inter vivos, that is among the parties. The entry 91 of the union list. So, sir, in our Constitution of India, there are 3 lists. One, the union list, which empowers the subject matters or subjects on which the center can make laws. Then there is a state list, which empowers state government to make laws on such subject matters. And third is the concurrent list, in which both the parties can make laws. So this stamp recording transaction collection of revenue by way of Stamps Act is given under entry 19 of the union list, and similarly entry 63 of the state list. So, sir, you have already so much experience, and you can tell everyone that this law today, the purpose, so what Supreme Court has highlighted today, that this law is merely to generate revenue and nothing else, and this law cannot be relied on to render a contract nullity and unenforceable. That's all.
Very well, Amar. So, Amar, like I would see, in case Ankit, somebody has another question here.
So Dr. Amit Gupta is asking, can you explain the concept by giving few examples of void as well as unadmissible documents? The second question that I think we can answer in the same maybe together is that when the defect is cured, what is the experience of maybe Amber and Lokesh, that is the stamp duty to be paid, or is there any enhanced duty including penalty that is required to be paid when the curation happens at a later stage?
Now, I understand. I have also read the law. The law is very clear that the stamp duty will have to be paid along with the penalty. And both has to be paid for making that particular document inadmissible as an evidence. That is very clear. And the court has a duty to impound that document if it is submitted before a court, and will be sent it to the registrar of stamps, and the registrar of stamps will determine the duty payable on that document. And that normally would be higher because of the penalty only. So
Now
we
the
also,
second question, sir, I would like to just
yes,
like to highlight, sir, that question was in relation to examples. So I would simply say that a contract with a person who is minor, an elder person is having a wagering contract. So wagering contracts are void ab initio the moment they are entered. So the moment I enter into a wagering contract, they are void. So they are not enforceable in the eyes of law. However, if I enter into a contract of bailment and I have not paid the proper stamp duty, if there is a provision to pay stamp duty, then that contract is not enforceable. It is only when I bring it to the record of court, I may not pay the stamp duty, but suppose I want to get it enforced, get it adjudicated, some rights adjudicated out of it, and I bring it to the court, the subject matter to the court, then the court will may or may not rely on it and will ask me to first pay the revenue, the stamp duty, and then only rely on it.
yes, I think this is also very correct. And other thing, Amar, that we also have been struggling in our NCLT, and in this particular judgment, also the Supreme Court has touched upon the issue of judicial discipline, maintainability. So the Supreme Court has said that in the case of Bharat Petroleum versus Mumbai Shramik Sangha, that was in 2001, it was stated that the rule of judicial discipline demands that a bench of lower strength is bound by the decision of a larger bench. Similarly, the judicial discipline also dictates that generally a bench of the same strength can question the correctness of a decision rendered by a coordinate bench. In such a situation, the matter is placed before a bench of larger strength. We are of the opinion, this is what the bench says, we are of the opinion that the reference by the 5-judge bench raises question of seminal importance with regard to the interpretation and applicable of the arbitration law in India, which in turn has implications for the business and commerce in the industry. So we also have handled some cases where the judicial discipline in NCLT, in fact, was also being argued. I would ask Amar to say something about judicial discipline as we practice in NCLT or NCLAT.
Sir, the very concept of judicial discipline is that it is a principle which the court among them, the benches among themselves agree that suppose if so there is a doctrine of stare decisis. Now the doctrine of stare decisis simply says that if a court which is supreme or which is in hierarchy above that court has given a judgment. So we have in our Indian judicial system we have Supreme Court, the High Courts, and the district courts or the tribunals. So if suppose a Supreme Court has given a judgment, then that will apply as the doctrine of stare decisis will apply, and then the lower courts will be bound by it. Now today, suppose there's arises another situation. Supreme Court bench, there was two benches. One bench of a single judge has given X judgment, and the other bench of division bench, that is two judges, have given Y judgment. Now, in that cases, there will be a lot of chaos among the common people to understand what is the law existing, because both of these judgments are coming out of the Supreme Court. So, just to cure that issue, there is the concept of judicial discipline was evolved. Firstly, in USA. So, how that it evolved in USA is that today, and how we are applying it today, that the stare decisis will apply as it is. But to cure that, one, a single judge bench does not makes a different opinion than a larger judge bench, we have adopted judicial discipline as a method that they are among the same court with a different bench strength, which a higher bench strength will have a superseding effect on a bench which is of a lower strength of the same court, so that we don't have ambiguity in operation of law.
So very right. So in NCLT, in case there is a judgment from the court of the NCLT president, is that becomes binding on the other benches?
Sir, of course, if there is a largest bench judgment of NCLT, suppose Mr. Today, if we say NCLAT has a practice of taking up matters by way of a larger benches, because they know that the same matter was adjudicated by a bench which is of less similar strength, suppose two judges bench.
Right.
So similarly, one subject matter I recall today was the matter that delay in refiling, whether it can be condoned or not. So initially, two judge bench of NCLAT of Mr. Justice Mukhopadhyay had decided, along with a other technical member, that this defect cannot be cured, and once you have delayed in refiling, your appeal will be dismissed by way of a defect in limitation. Today, when the question arose before Mr. Bhushan, what he did, that he made up a bench of a larger strength. The same NCLAT with a larger strength decided the same issue, but just opposing, in an opposing manner, where they said that this is a defect which can be cured by the registrar, and court is not supposed to be involved, because delay in refiling is condonable by the registry itself.
So right. So this is what we wanted, that our audience should understand, that this is what is the judicial discipline, and it is to be maintained by the courts. This is what also has been touched upon by this 7-judge judgment of Honorable Supreme Court. See, this particular judgment, Ankit, has also dealt with the importance of Arbitration and Conciliation Act. I'm saying that the conciliation may be removed after the Mediation Act becomes implemented fully, but this arbitration definitely has been enacted. It is said that the enactment of Arbitration Act was done with the aim of providing speedy, efficient, and binding resolution to parties who have submitted the dispute to arbitral tribunal. Then this court is also trying to mention this arbitral autonomy and minimum judicial interference is required. Arbitral tribunal should be completely autonomous, and minimum judicial interference should be done. That is also something which is mentioned. And it is also mentioned that the Arbitration Act is a self-contained code, and it is actually empowered to everything what a normal court can do. The principles of modern arbitration is also discussed. Law on the arbitration agreements has been discussed a lot. What kind of arbitration agreements are there and how it is important. And then this particular judgment also says separability of the arbitration agreement from the underlying instrument is one of the salient features of arbitration law. And according to this principle, an arbitration agreement is jurisdically independent from the underlying contract in which it is contained. This separability is based on following factors. One, the intention of the parties to refer the dispute to arbitration, including a dispute over the validity of the instrument. Preventing unwilling parties to submit to arbitration by alleging validity of the instrument. Insufficiency in the completion of formalities concerning the instrument should not affect the validity of the arbitration agreement. So this is where I said that this, even if the underlying instrument is void, still the arbitral tribunal can also decide whether the underlying commercial instrument, commercial agreement is void or it is valid. So that is also the power of the arbitration tribunal. This is also very important part. So the so according to my understanding, the stamp duty is important. However, the stamp duty is not supposed to invalidate a commercial contract or even an arbitration agreement. No, this is the basic concept which is given in this law, and I can still ask. We have already touched upon the minimum judicial interference is required. And could you understand about this doctrine of competence, Amar, which is
Uh,
again mentioned?
Sir, in what reference? Doctrine of competence?
The doctrine of competence is mentioned in this particular judgment a lot. And in fact, that is something that a qualified lawyer would be able to understand. But in case you have not prepared, we actually have many more questions still we can talk about. So, Amar, the basic issue
Sir,
now is,
the doctrine of competence is primarily a principle which says that if the parties are challenging the jurisdiction of the court to entertain a dispute, then the court simply cannot entertain it. So that is, the court has to first determine whether it has jurisdiction to entertain that dispute or not. So this entire subject matter which was decided by Supreme Court, we must see in what context it was decided. It was decided because there were certain challenges to arbitral proceeding merely on account because there was non-payment of stamp duty on the arbitration agreement. So parties who were non-willing to come into arbitration, although entered an arbitration agreement, simply said that the stamp duty has not been paid and the court is not competent to rely on the arbitration agreement, and so subsequently the tribunal cannot function and decide and adjudicate this issue.
so I think you are absolutely right. See, in another judgment, Honorable Supreme Court, again, it's a constitutional bench with 5 Supreme Court judges. That is in the case of Cox and Kings Limited versus SAP India Private Limited. So in this case, the validity of a group of companies doctrine in the jurisprudence of Indian arbitration was also discussed. And this was also a judgment on 6th of December, and it was also on arbitration and also kind of, so the question of law in this particular judgment was whether non-signatories can be included as parties to an arbitration agreement. If so, under what circumstances can non-signatories be included as parties to an arbitration agreement? Because see, basically it's a concept of group of companies. So in case one particular company has entered into an agreement, and that to an arbitration agreement, and there are other companies which are non-signatory to that arbitration agreement, whether they also can be included as parties in the arbitration agreement or not. This was the case of the Cox and Kings versus SAP, and we are not going by the kind of judgment. We are only saying that this is what was finally discussed in the Supreme Court, and we are not bothered about the facts. No, the Supreme Court says that an arbitration agreement must satisfy the principles of contract law laid down under the Contract Act, in addition to under satisfying other requirements stipulated under Section 7 of the Arbitration Act to qualify as a valid agreement. An agreement enforceable by law is a contract. Consensus ad idem between the parties forms the essential basis to constitute a valid arbitration agreement. The court further says it is generally accepted legal proposition that arbitration is a matter of contract, and a party cannot be required to submit to arbitration any dispute to which they have not agreed so to submit, since consent forms the cornerstone of arbitration. A non-signatory cannot be forcibly made a party to an arbitration agreement, as doing so would violate the sacrosanct principles of privity of contract and party autonomy. Now, let us finally see the other issues handled in this judgment. Give me 1 second. So the conclusion in this particular case was, which was given by 5 Supreme Court judges. One, the definition of parties under Section 2, subsection 1, clause H, read with Section 7 of the Arbitration Act, includes both the signatory as well as non-signatory parties. It further says, conduct of the non-signatory parties could be an indicator of their consent to be bound by the arbitration agreement. The requirement of a written arbitration agreement under Section 7 does not exclude the possibility of binding non-signatory parties. Under Arbitration Act, the concept of a party is distinct and different from the concept of persons claiming through or under a party to the arbitration agreement. The underlying basis for the application of the group of companies doctrine rests on maintaining the corporate separateness of the group companies while determining the common intention of the parties to bind the non-signatory parties to the arbitration agreement. The principle of alter ego or piercing the corporate veil cannot be the basis for the application of group of companies doctrine. The group of companies doctrine has an independent existence as a principle of law, which seems from the harmonious reading of Section 2, subsection 1, clause H, along with Section 7 of the Arbitration Act. To apply the group of companies doctrine, the court or tribunal, as the case may be, have to consider all the cumulative factors laid down in ONGC versus Discovery Enterprises Private Limited. That was the judgment given in 2022 by Honorable Supreme Court. Resultantly, the principle of single economic unit cannot be the sole basis for invoking the group of companies doctrine. The persons claiming through or under can only assert a right in a derivative capacity. The approach of this court in Chloro Control Private Limited versus Svern Trend Water Purification, it was a 2017 judgment, to the extent that it traced the group of companies doctrine to the phrase claiming through or under is erroneous and against the well-established principle of contract law and corporate law. The group of companies doctrine should be retained in the Indian arbitration jurisprudence, considering its utility in determining the intention of the parties in the context of complex transactions involving multiple parties and the multiple agreements. So this particular judgment, again from in the month of December by a constitution bench, 5-judge bench, it also kind of says that the other parties of the other companies of the group, other members of the group can also be included as party to an arbitration matter which is pending before an arbitral tribunal. So there are guidelines given to the arbitral tribunal that these are some guidelines which actually can be seen like the kind of the actions of the other entities. Also, that has to be determining factor whether those parties are active parties in this commercial law or underlying law contract. So that actually will be decided by the tribunal itself. So Ankit, can we see if there is a question now on this arbitration matter?
We have a question from Lalit Maheshwari ji. He's saying that the registrar of stamps sees only the value of duty to be paid. He never goes into the validity of title of documents. Then he talks about that if a forged document is registered with adequate stamp duty, what is the status of that document? So I think that's a separate defect, Lalji, the stamp duty and
Like a
compliance.
forged document, Ankit, forged document is basically void ab initio. When anything is void ab initio, the payment of stamp duty admissible as an
Cure it.
evidence
Does not cure
all
it. So there is no
doesn't cure
possibility
it.
that the stamp
Doesn't cure
duty
it.
cures it. A document which is a forged document where there is forged signature will have other defects because of which it will become unadmissible. We have a
No, but
raised hand. Yeah, yes, Amar.
yeah, sorry, you can continue.
Nothing. I was just
Moreover, sir, it is a criminal offense. We all know under 463 forgery is defined of the IPC. I don't know the new provision, what provision under the new law the forgery is defined. And under 464, you can file a case for forgery. So it is a criminal offense. And like Anil sir said, it is void ab initio, so it is not enforceable.
Yes, Amar.
have a raised hand. We have Mr. Kanikal Chandru raising his hand. I'm allowing him to speak. You can unmute and say yes. Yes, your voice is very feeble. Maybe you can try to be a little louder or maybe
Yeah. Yes. No, just wanted to confirm, Mr. Anil Goel was just mentioning that the principal judge judgments, are they binding on all the NCLT benches of the country, or only the unclad judgments are binding?
No, I think Amar, in fact, tried to reply that because if the principal bench or the chairman's bench in the case of NCLAT, it still maintains this is two judge or two member bench. It doesn't make them three member bench because Amar also said very clearly that now in case we see that there is a judgment from any other bench of NCLAT, so what actually Mr. Ashok Bhushan does every day is that then he would have a three-member bench so that he would give a final judgment. So principal bench or the chairman's bench, it may have some administrative value, but it actually in the court, as per this particular judgment of Honorable Supreme Court, this will not be considered as
Very correct, sir.
three-member.
Very correct.
Three-member, yes, Amar.
Thank you.
Am I correct, Amar?
No, sir, we are very correct.
Yes. So it will not be considered as a kind of larger bench. It will not be considered as a larger bench. Administratively, it may have some impact. So we also have to discuss, Ankit, today another judgment, a very, very small judgment, but have a lot of impact on our practitioners. This is in the case of Sanjay Padurang Kalati versus Vistara ITCL India Limited. The judgment is dated 4th of December 2023, and it has come from, again, the Chief Justice of India and Justice J.B. Pardiwala and Justice Manoj Mishra. Now, judgment is very clearly handling one issue, that one issue of the question of law is it legally mandatory to pronounce orders without assumption, and should the Honorable NCLT refrain from dating orders with the hearing day if the hearing and order pronouncement occurs on separate dates? Now, what is the background of this particular judgment from Honorable Supreme Court? That we all have seen that the orders are, first of all, reserved for orders, and thereafter it is not pronounced in the court. And some fine day we see that the order is uploaded on the website of NCLT or NCLAT, and then we try to find out what is the date of this order. And when we see the date of that order, the date would be the date of the last hearing. It is the basically that particular issue that the date of the last hearing cannot be the date on the order in case the order is pronounced later or order is uploaded on the website later. See, either the order has to be dictated in the court so that all the parties present must know the contents of the order, or the order has to be reserved for order so that it will be pronounced later. So there is nothing like that the order is not dictated during the order. It is reserved, and finally the uploading is done later, and the date of the order is matching with the last date of hearing. So in this case, now you would not see, you would rather see every day many orders will be listed for pronouncement, because this has become now the Supreme Court judgment that all courts would first, maybe if it is not dictated in the court, then they will have to say that it is reserved for order, and there will be another date for pronouncement of order, and the date of reserving and the date of pronouncement would be mentioned, and the limitation period for filing appeal would start from the date of pronouncement and not from the date of the reserving the order. Is that correct, Ankit, or our understanding is correct?
Yes, yes.
Or
Correct,
Amar,
sir.
Amar, what do you say about this? Because I think we all have been facing these difficulties that the uh, NCLAT is not condoning the delay, and the gap between the, in fact, we suffered ourselves, the gap between the last hearing and the uploading of the order on the NCLT website was huge, and we, in fact, could not file appeal. We suffered in one case. Yes, Amar.
Correct, sir. The Supreme Court has identified this issue and was forced to decide it, because ultimately it was creating a lot of problem for, especially for persons who were largely affected by the impugned orders given by the NCLT. So what Supreme Court has today decided, that to ensure that every person gets a chance to appeal the impugned order, there must be a reasonable time given to that party. Now that there, so the second thing that was needed to be decided, when that reasonable time is to commence. So by deciding that, you cannot simply say that in your once you have reserved the order, you cannot simply say that the order is backdated when the hearing has happened, and the limitation would start from that day. So it would render ineffective Section 61 of the IBC, which says that any person aggrieved by an order may file an appeal within stipulated time of 45 days. So just to make sure that the party have their right of appeal and they are not prejudiced merely by a method of SOP, which was very prevalently being adopted by NCLT especially. So just to cure that, they simply said that we need to clear it out.
So very well, I think now in between, I saw Advocate Lokesh Malik was logged out. Now I think Lokesh Malik is also here. Lokesh, would you like to add on the various subjects that we have touched upon today? Not
Right,
in
sir. I want to shed light on the doctrine of competence.
right.
It has been a basic law. It turns out from the Section 16 of the Arbitration Act. The basic idea about that law and doctrine is that the tribunal itself is competent to decide on its jurisdiction.
Okay.
Whatever may be the criteria or the challenge against the invalidity of the arbitration agreement, the jurisdiction, validity and invalidity of the jurisdiction of the particular arbitral tribunal is to be challenged before the arbitral tribunal itself, and the arbitral tribunal is competent enough to decide upon it, and that can only be challenged in a 34, and no appeal lies from those orders.
Very
On
well.
the
I think
second,
very
on
well.
the second hand, if we see the doctrine of severability, the doctrine of severability arises out of which clearly says that any agreement containing the arbitration clause, that arbitration clause is supposed to be treated as an independent agreement, but the agreement, when unstamped, will not render the arbitration clause as inadmissible or inenforceable.
Right. Right. So I think very well. So Ankit, any questions?
We do have a Question from Anand Pandya ji, who says whether the date of pronouncement of order or date of uploading on site to be taken into account when you're filing these appeals. That's his question.
Date of pronouncement of the order. Even after the pronouncement, if there is a delay of 2-3 days in uploading, because the announcement means that you have a right to apply for the certified copy on the very hour when the announcement is done. And you can actually apply for the certified copy of the order on the very date, on the date of the pronouncement, immediately after the pronouncement, and even the time taken for obtaining the certified copies is also excluded from the limitation for filing any appeal. So the date has to be the date of pronouncement which is mentioned, and not the date of uploading of the order, because our right to get certified copies starts immediately after the pronouncement.
Correct. I like to add something on this, that when the orders are pronounced, the orders are signed there and then and are finally prepared. When the orders are reserved or are not uploaded, which can eventually mean that the orders are not ready, hence certified copies cannot be applied for.
Very right, very right. So the certified copies can only be applied once the order is pronounced in the court. Any other question, Ankit?
That's about it. We don't have any pending questions or any raised.
So, thank you very much, Advocate Amar Vivek. Thank you very much, Advocate Lokesh Malik. We have completed 1 hour, and as you know, we always say that
Thank you so much, sir.
This is our way of learning, and no other reason for our continuing with this passion, because this is our way of learning. So we learn this way. Thank you very much. Thanks a lot.
Thank you, everyone.
Thank you, sir, so much. Always a pleasure.
Thank you.